I'm Lavinia, and I work with CCPR Center. I have the pleasure to be here today with Mrs. Rachel Brett, who will be telling us about this case, which was recently decided by the Human Rights Committee, called Atasoy and Sarkis versus Turkey. So, Mrs. Brett, in what respect was this a particularly important case?
Mm-hmm. Well, this was a case about conscientious objection to military service in Turkey. And it's important in a number of ways. First of all, because this was actually the first case against Turkey that the Human Rights Committee had. Because Turkey only relatively recently became a party to the Covenant on Civil and Political Rights. And so it was important for Turkey, and it was important because it came recently before Turkey has now just been considered by the Human Rights Committee in the reporting process. So it also fed into that. For the committee, it was important because this was the first conscientious objection to military service case that they'd dealt with as an individual case other than from the Republic of Korea. So it was a different country. And then it was important because these conscientious objectors, in fact, have not yet been sent to prison. There were two of them. They were Jehovah's Witnesses. They'd both been convicted a number of times and sentenced to imprisonment, but then it had always been commuted into a fine. Whereas the previous cases, the individuals had all been in prison. And in addition, one of the Turkish men had actually lost his job because of his refusal to do the military service. So the committee was also looking at this kind of a discrimination or a penalty, if you like, but not a legal penalty in that sense. In terms of the substance, what was very important was that, yet again, the committee was unanimous that this was a violation of Article 18, the right to freedom of thought, conscience and religion. But there was a disagreement as to why it was a violation, with the majority saying it's a violation of Article 18, paragraph 1, the right to freedom of thought, conscience and religion itself, because this is inherent in that right. And the minority saying that it was actually a violation of Article 18, paragraph 3, a manifestation of your religion or belief. Why does that matter, and how did the committee get this distinction? Came about because the very first case in which the committee actually held that there was a right to conscientious objection to military service, they in fact agreed that it was a manifestation of your religion or belief. Subsequently, there were two further sets of cases from the Republic of Korea, and in the third of those sets was when the committee actually shifted its view and the majority said not manifestation but inherent. And so the committee is going on with this sort of discussion amongst its membership. The practical implication is if it's inherent, then there are no limitations permitted. If it's a manifestation, then there is provision that certain limitations can be put on that in certain circumstances, but they have to be justified. So those who say it's a manifestation then go on and say, has the government actually made the argument as to why, and is this a legitimate argument as to why this manifestation can be limited? But those who say it's inherent are very clear that if you look at it in that way, you could end up saying in certain circumstances, oh well, perhaps someone can be forced into the armed forces and therefore faced with an obligation to be involved in the use of lethal force against their conscience, which may be a religious belief, it may be a conscience not based on a religious belief, but just pacifism. that's really the crux of the difference within the committee. And the majority are saying that is simply unacceptable, because we accept that those limitations that are allowed in relation to manifestation of religion or belief may not vitiate the right itself. But if the right is actually a right not to have to use or be associated with the use of lethal force, then surely the argument makes sense that actually it's inherent, because you cannot have a limitation that would not vitiate the right if you accept that in some circumstances people could be forced to behave in this way against their conscience.
Would that mean that whenever it comes to conscientious objection to compulsory military service, could it never be restricted, and is it specifically applied only to compulsory military service?
These cases have all been in relation to the military service, and there has been an earlier case where it was a question of not paying some of the money for taxes to fund the armed forces. And the committee at that point said, no, this is not included. That's quite an old case. They haven't looked at it again recently. They haven't had a case in which to look at it recently. And this, again, clearly is one of the question marks in the members' minds, the committee members' minds. Again, those who are saying inherent were saying we shouldn't be looking at other possible cases because we're not dealing with them. We will have to address those when we deal with them. But it is very clear that those who are saying inherent, and I suspect the others as well, but they don't have to make the argument to the same extent, and where the committee's general comment 22 on Article 18, it's that intersection of the use of lethal force, in that sense, the right, if you like, the right to refuse to kill, or to, in that sense. And it is that, it's the link between the conscience, religion, belief, and the refusal to kill that is really the crux of it. So it's unlikely, I'm not saying it's impossible because we don't know, but it's unlikely that if it was not something that nature, that the committee would necessarily say that it is protected at all, let alone whether that it's inherent and not a manifestation.
And regarding a claim of right to conscientious objection to compulsory military service on the ground of ethnic belief, what's the position of the Human Rights Committee jurisprudence in this regard?
The committee has actually, it's now had 4 cases, all of which involve more than one person. 3 of those cases, including this latest Turkish one, were Jehovah's Witnesses, and no one, least of all the governments, were questioning, one, that it was a religious belief and that it was genuine, and that they accepted that Jehovah's Witnesses have this position. The other case, which was in fact the second case from South Korea, the Republic of Korea, Jung and others, did not involve Jehovah's Witnesses. It involved a Catholic, a Buddhist, and a number of other objectors, some of whom were non-religious objectors, and the committee had no problem with this at all. So they clearly do accept that, their definition of religion or belief is wide in any case, but they accept that this is also a question of conscience in that sense, that it doesn't necessarily need to be a religion or a religious belief or a recognized religion or any of those kinds of qualifications. So I don't think there's any problem in that regard. The argument would simply be, can the person demonstrate, in a sense, that they really hold this position? Now, if you have refused and been sent to prison for refusing to serve in the military, I challenge most people to consider that this does not demonstrate the seriousness of your conviction. And I think that was clearly, the committee did not feel the need to explore that aspect any further.
I'm very pleased to hear this. Thank you very much for the very valuable information you provided us today. So thank you for being here.
Pleasure.